If you own your home outright and you live in one of 5 specific states, the equity you spent 30 or 40 years building is being quietly transferred away from you right now through a mechanism that operates inside obscure county-level tax statutes, and most of the homeowners it affects never realize it is happening until the bill arrives or the deed is no longer in their name. This is not a standard property tax situation. It is not a mistake or an administrative error. It is a legally sanctioned equity transfer that has been operating for decades, and a landmark Supreme Court decision in 2023 only stopped part of it. The remainder continues today in every county across these 5 states, and in 2 of them, the situation is actively getting worse. The homeowners most exposed to this mechanism are not the ones who are struggling financially. They are the ones who did everything correctly. The ones who worked for decades, paid off their mortgage, and assumed that the equity sitting inside that home belonged to them. That assumption is only as safe as the county-level statutes written decades before most of those homeowners were born. In 4 of the 5 states we are about to walk through, there is a single filing available at a county or town office for under $75 that quietly neutralizes the worst of this mechanism. We will tell you exactly what that filing is before this is over. But first, you need to understand which states still have this rule written into their books, how the mechanism actually works in each one, and why seniors with fully paid-off homes are the group standing in front of the largest potential losses. Start with the case that forced this mechanism into public view for the first time. A 94-year-old widow named Geraldine Tyler owned a 1-bedroom condominium in Hennepin County, Minnesota. She fell behind on her property taxes. The total amount owed, including penalties and accumulated interest, came to approximately $15,000. Hennepin County seized the condominium, sold it for $40,000, kept every single dollar of that sale, and gave Geraldine Tyler absolutely nothing in return. Not a check. Not the difference between what she owed and what the property sold for. The county absorbed $25,000 of equity she had spent decades building and called it entirely legal under Minnesota law. For years, courts in Minnesota and several other states had held this was perfectly acceptable. The reasoning was that once a homeowner falls behind on taxes, the entire property is forfeited, not merely the unpaid portion. If your home is worth $400,000 and you owe $10,000 in back taxes, the state could take the entire property and keep all $390,000 of your equity. Geraldine Tyler took the matter to court. In May of 2023, the United States Supreme Court ruled unanimously in Tyler versus Hennepin County that this practice violates the Takings Clause of the Fifth Amendment. The Constitution says the government cannot seize private property for public use without providing just compensation. Taking $25,000 of equity over a $15,000 tax debt is a taking without compensation in plain terms. But here is precisely where most people stopped reading and missed everything that followed. The Supreme Court did not eliminate property tax sales. It only ruled that the surplus, meaning the equity above the amount of the actual tax debt, must be returned to the homeowner. The seizure can still happen. The auction can still proceed. The home can still be lost. The only change is that the county must now send a check for whatever remains after the debt is satisfied. And that is exactly where the next layer of losses begins. In Minnesota, following the Tyler ruling, the state amended its tax forfeiture statute in 2024 to bring it into compliance. Surplus funds are now held in a state account, and the former owner can submit a claim within a defined time frame. But the claim form is not sent to you automatically. The county is required to notify you, but that notice is mailed to the address on file. For a senior who has relocated to assisted living, or for an estate in probate with no one actively monitoring incoming mail, that is frequently the wrong address. The notice arrives, the deadline passes, and the surplus stays with the state. This pattern repeats across all 5 states in slightly different forms. The federal ruling closed the front entrance. State legislators left the side entrance wide open, and the people walking through that side entrance are primarily investors and attorneys who are aware the surplus window exists, almost never the senior whose equity is sitting in an escrow account waiting to be claimed. A 2-minute phone call to your county auditor asking whether your name appears on any surplus list from a tax sale in the past 2 years resolves this in Minnesota. But it is the kind of call almost no one makes because almost no one knows it needs to be made. The broader lesson from the Minnesota situation is that the Tyler ruling created a right that only benefits people who know the right exists and know the process for claiming it. Rights that require active assertion to be exercised are effectively invisible to the people who most need them, and that is precisely the condition that has allowed this mechanism to continue absorbing senior equity even after the Supreme Court intervened. Nebraska operated one of the most severe equity stripping systems in the country before Tyler. The state used a tax certificate sale that allowed private investors to purchase a tax lien, hold it for 3 years, and then file for a tax deed, transferring complete ownership to the investor. The original homeowner could redeem during that 3-year window by repaying back taxes plus interest at a statutory rate of 14%. A $3,000 tax debt could therefore balloon to over $4,500 before the redemption window closed. In one documented Nebraska case from the late 2010s, a homeowner lost a property worth nearly $200,000 over a tax debt of less than $6,000. The investor walked away with all the equity. The homeowner received nothing. Following Tyler, Nebraska updated its rules to mandate surplus return, but the certificate sale mechanism remains active. Investors still purchase tax certificates and earn statutory interest. The senior homeowner still has a redemption clock ticking the moment they fall behind. Nebraska statute allows the county and the certificate holder to deduct what are called recoverable costs from the surplus before dispersal. Those costs include attorney fees, title search fees, recording fees, and statutory interest accrued during the redemption period. In most Nebraska counties, those deductions average between $3,500 and $4,500 per case. A senior entitled to $20,000 in equity surplus may actually receive $16,000 or less after deductions. That $4,000 loss does not constitute theft under the law. The Tyler ruling does not prohibit reasonable administrative fees, but for a senior on a fixed income, $4,000 of equity disappearing into procedural charges can represent the difference between a year of in-home care and placement in a state facility. Nebraska offers a homestead exemption for property owners over 65 with limited income that reduces the assessed value of the home or, in some county programs, defers the property tax bill entirely until the property is sold. The deferred amount becomes a lien on the property but does not accumulate interest at the higher statutory tax rate. A senior who qualifies for the deferral avoids the certificate sale process entirely and preserves the equity inside the home. The application is submitted to the county assessor, carries no cost in most counties, and can be completed in a single visit. Very few eligible Nebraska seniors use it because almost no one informs them it exists. New Jersey presents a different version of the same problem, but with larger dollar amounts involved. The state routinely carries the highest effective property tax rate in the nation. The average homeowner in counties such as Bergen, Essex, and Union pays between $12,000 and $18,000 per year in property taxes on a single-family home. For a senior who paid off the mortgage 2 decades ago, that bill is frequently the largest single expense remaining in retirement. New Jersey operates a tax lien sale similar in structure to Nebraska's system, but with a critical distinction. The interest rate on a delinquent tax lien in New Jersey can climb as high as 18%, plus an additional 6% penalty on the original balance. A $5,000 property tax shortfall can therefore grow to over $10,000 within 3 years. New Jersey also allows municipalities to declare a property abandoned if it sits vacant for 90 days, which compresses the redemption window from 2 years down to as few as 45 days. A senior who relocates to assisted living while the family decides whether to sell can have the property declared abandoned by a code enforcement officer. In an average New Jersey tax foreclosure involving a paid-off senior home, the surplus after Tyler can range between $20,000 and $50,000. But permissible deductions under New Jersey statute include attorney fees in expedited foreclosure proceedings that routinely run between $3,000 and $4,000 per case, along with lien interest, the statutory penalty, and municipal administrative charges. The $4,000 equity loss in New Jersey is nearly guaranteed in any case that reaches foreclosure. The most effective defense is preventive. New Jersey offers a program called the Senior Freeze, a property tax reimbursement available to homeowners over 65 with household income below the annually revised cap. The Senior Freeze locks the property tax bill at the level it was during the first year of qualification, and the state reimburses the homeowner for any increase in subsequent years. A senior whose bill rises from $12,000 to $15,000 over 5 years receives a reimbursement check for the $3,000 difference annually. The application is filed with the New Jersey Division of Taxation at no cost, but it must be submitted every single year without exception. Missing 1 year resets the freeze at the new and higher base amount, which in many cases means a permanent increase of $2,000 or more in the annual bill going forward. Illinois had one of the most aggressive equity-stripping tax sale systems in the country before Tyler. Cook County, which contains Chicago and accounts for the majority of Illinois property values, was the center of this activity. In documented cases, Illinois homeowners lost properties valued between $150,000 and $400,000 over tax debts as small as $4,000. Following Tyler, Illinois rewrote its tax code to mandate surplus return, but homeowner advocacy groups have characterized the rewrite as insufficient. The statute still allows certificate holders to recover collection costs, attorney fees, and statutory interest before the surplus reaches the former owner. In Cook County, average deductions in post-Tyler cases run between $3,800 and $5,200. A senior entitled to $30,000 in surplus may receive approximately $25,000 after deductions. Illinois offers 2 protective filings. The first is the Senior Citizens Homestead Exemption, available to homeowners over 65 who occupy the property as their primary residence, which reduces the equalized assessed value of the home and generates annual tax savings commonly falling between $400 and $700. The second and more powerful option is the Senior Citizens Real Estate Tax Deferral Program. An Illinois homeowner over 65 with household income below the annual cap can defer property taxes entirely. The deferred amount becomes a lien at a low statutory simple interest rate, settled when the property is sold or transferred. The senior never falls behind, never enters a tax sale, and never loses equity to surplus deductions. The deferral application is filed with the county treasurer at no cost in most counties. Very few eligible seniors use it because the program receives minimal publicity, and most seniors mistakenly believe deferred taxes create complications for their heirs. That concern is the opposite of reality. The deferred lien accruing at a single-digit statutory rate is far more favorable than the far higher interest charged on a delinquent tax lien, and the lien is structured to be retired cleanly at the time of sale or inheritance with no unexpected penalties attached. Massachusetts is the most active state on this list because the equity conflict there is unfolding in real time. The state has a long-standing property tax cap statute called Proposition 2-122, which restricts annual property tax increases to 2.5% plus growth from new construction. But numerous Massachusetts municipalities have moved to override that cap through a ballot mechanism. An override is a question presented to local voters requesting authorization to raise property taxes beyond the cap to fund a specific project, such as a school, public safety facility, or infrastructure improvement. In many recent municipal elections, override votes have achieved majority approval. For a senior on a fixed income in a town where an override passes, the resulting bill can rise by $1,000 to $4,000 per year, with no ability for the senior to prevent it because they represent a minority of the electorate. Beyond the override mechanism, several Massachusetts municipalities have begun exploring what is informally called the unrealized equity tax, a property tax surcharge applied to the appreciated value of a home above its original purchase price. None have passed as of early 2026, but discussions are actively taking place in town meetings and legislative committees, and homeowner advocacy groups are monitoring the situation closely. If one passes, a senior who purchased a home for $150,000 and watched it appreciate to $700,000 would owe tax on $550,000 of unrealized appreciation. At even a 1% rate, that amounts to $5,500 per year in cash owed on equity the senior has not yet accessed or converted to income. Massachusetts offers two protective filings. The Senior Circuit Breaker tax credit is available to homeowners over 65 whose property tax bill exceeds a defined percentage of their annual income. It is filed with the Massachusetts Department of Revenue as part of the standard state income tax return at no cost and is refundable, meaning that if the senior owes no state income tax, the credit is paid as a direct check. The Clause 41 local property tax exemption is available in most Massachusetts municipalities for homeowners over 65 and is filed annually with the local Board of Assessors at no cost. Combined, these two filings can offset between $2,500 and $4,400 of annual property tax liability. Now for the filing promised at the beginning. In 4 of these 5 states, there is a single county-level filing that costs under $75 and neutralizes the core of the equity stripping mechanism. That filing is the Homestead Declaration. In Massachusetts, it is called the Declaration of Homestead. In Illinois, it is the Senior Citizens Homestead Exemption. In Minnesota, it is the Homestead Classification. In Nebraska, it is the Homestead Exemption. Each of these filings carries a different name, but the same essential function and the same protective effect. New Jersey is the only state on this list without an equivalent statutory homestead protection of comparable scope. The Homestead Declaration designates the property as your primary residence and shields a defined portion of the equity from creditors and forced sale. In Massachusetts, that protection extends into the hundreds of thousands of dollars. The filing fee in most counties falls between $35 and $75, and the protection is permanent for as long as you own the property, commonly extending automatically to a surviving spouse. Here are the 5 concrete steps to take this week. First, determine whether you live in Minnesota, Nebraska, New Jersey, Illinois, or Massachusetts. If you do, your exposure is at its highest right now. Second, file the Homestead Declaration in your county or town immediately. It is the single highest yield protective filing available to most senior homeowners and costs under $75 in most jurisdictions. Third, request a copy of your most recent property tax assessment from the county assessor and compare the assessed value against recent comparable sales in your neighborhood. If the assessed value exceeds current market value, file an abatement application at no cost. A successful abatement commonly reduces the annual tax bill by several $100s. Fourth, determine whether your state offers a senior tax deferral program. Illinois, Nebraska, and several other states allow homeowners over 65 to defer property taxes entirely, with the deferred amount becoming a low-interest lien paid off at the time of sale. Fifth, schedule a single consultation with a licensed elder law or real estate attorney in your state. A consultation covering homestead filing, tax deferral eligibility, and surplus claim procedures from any prior tax sale commonly recovers more than its own cost within the first year of correctly filed exemptions. The equity you built over a lifetime deserves the same level of active protection you gave to building it. These mechanisms do not announce themselves. They operate through paperwork, deadlines, and procedures that most people never encounter until it is already too late to respond. The defense is a collection of small and inexpensive filings that together create a wall between your equity and the process designed to absorb it. None of them are complicated. All of them are accessible, and every one of them becomes more powerful the earlier it is put in place. This is Social Security Vault.